the one thing that I really decided kind of late in terms of creating the podcast was I initially wasn't going to inject the fact that I was a criminal defense attorney into it. I told my wife, I'm like, nah, it's like I'm trying to get away from that. And then I realized very, very shortly into the journey that was the wrong approach. And, I just want people to kind of understand that the justice system that we live under, we need both sides, and we need competent attorneys on both sides, because that's the only way that justice can be done for the victims, for their families, is having competent counsel on both sides, because it's the only way that justice works.
This is the Silver Linings Playbook. I'm Jason Blair. That's Bob Motta, a longtime defense attorney who's the host of the spectacularly rated true crime podcast, Defense Diaries. This is the second episode of a two-part series with Bob. Bob has practiced law for 2 decades as a defense attorney. If you haven't had the chance, I'd recommend catching part 1, where we discuss what got Bob into criminal defense law, his brief career in social work, what led him to start his podcast, and both the role of criminal defense attorneys in our society and what their lives are like. We also discuss the murders of 4 college students at the University of Idaho in 2022 and the Adnan Syed case, which led to the podcast Serial, which ushered podcasting further into the mainstream. After practicing law for 2 decades, Bob opened up a box that his father gave him on his 21st birthday, filled with tapes between his father's client, John Wayne Gacy, and Gacy's attorneys. Bob used those tapes to record the first season of Defense Diaries. Bob's second season, called Tunnel Vision, is about his own client, Dr. Anthony Garcia, who was convicted of 4 murders in Nebraska. In the last episode, we left off discussing the media coverage of the Garcia trial. Today, we're going to talk more about the Garcia case and some of the doubts that came up in that case. We're also going to touch on the Alex Murdough case, the Delphi murders, the burden defense attorneys carry, and those who have been exonerated long after being convicted. Why did you pick this one as a good case to talk about the criminal justice system?
Oh man, dude, because I lived it. You know what I mean? Like I'm a first source guy, and
right.
Like there in that case, like I sat there with. It was the only case I ever tried with my father, and it was his last trial. And he sat with me towards the end of it, like when I was preparing for my closing argument, because he actually second chaired me, which I took as a huge badge of honor.
Nice.
And he looked at me and he said, Bob, he's like, I tried John Wayne Gacy, and procedurally that case absolutely paled in comparison to this case. Like I've never seen or heard of a case like this. Like procedurally, dude, it was, and when I say hard fought, like it's an understatement. Like Don Klein, who is the county attorney out there, him and I on more than one occasion were nose to nose, like, and I mean behind closed doors type thing. Where we were both passionate about our job. And it's tough because there's a dynamic that I've got my wife, who is the love of my life, who's my soulmate, who is being attacked in a way that went, at least in my estimation, went beyond professional.
And she got pushed off.
She got booted off the case for making what they call an extrajudicial statement to the press when we had discovered something about the DNA, and we felt that it had exonerated our guy, and so she made this thing, and this is like. And typically there was no gag order on us. All right. And they had been trying my client in the press for 3 years. So there's this rule in the ethics rules for lawyers, because there are rules, believe it or not, that we have to follow. And it's called the safe harbor, where if your client is being tried in the press and the prosecution is making statements, and Don Klein was doing like fireside chats on the news about our client and, talking about the facts of the case. I mean, they were trying him in the press, like unequivocally. So we believe that it was a safe harbor for her to be able to make this statement.
Well, because also that's another reality I think people don't get. They think the impartial jury is supposed to go behind the scenes, not pay attention to what's happening in the press. But the reality is, like, your brother, your cousin, or you may look at the press, but that information finds its way back to the jurors.
Dude, are you kidding me? Like in that case, like, that's what I was saying. We polled. We knew. It was in Douglas County. They all knew the case. Like there wasn't there was not one juror on our jury that had not heard of the case.
Tell me about the case and the trial itself, and what ultimately happened with it.
So ultimately, he's convicted. I mean, he slept through his death penalty case. That's what I'm saying. It's like it didn't matter what I said. Like the facts did not matter in that case because of appearances. Any jury that looks at a man sitting there sleeping through his own death penalty case immediately believes that he's guilty, right. Period. And that's why I'm saying we had no idea. And it's completely a violation of civil rights that they were giving this guy, they were knocking him out, man. Like they were giving the guy a tranquilizer. I've got like proof of it. Like I've got the guy who was administering it.
Do you think the prosecutor?
I don't know, dude. I can only guess. All I can tell you is that they spent millions and millions of dollars investigating that case and trying that case. Like this concept that people don't seem to understand is that money is spent when cases are tried by the state. And if it's a high profile case, I'm talking millions and millions of dollars and manpower hour. It's like
testing,
travel, testing, all of it, dude. It cost a fortune. And once they had landed on Garcia as the guy, based on, and at the point that they arrested him, they had nothing more than mere presence in the state. Because as you'll find out, there was no forensic evidence whatsoever at either of the two crime scenes linking my client to either of these brutal, brutal double homicides, in which both cases knives were used. And if you know anything about the commission of a crime, and in particular a murder with a knife, especially with Mary Brumbeck, who had just an ungodly amount of defensive wounds, that the woman fought for her life. Typically what happens, because knife fights aren't like they happen in movies where somebody's just like, it's like people, there's flailing arms.
You're inevitably going to knife yourself you're
going to nick yourself at very least, or you're going to leave some DNA somewhere.
Right.
And you've got this situation where this happened at 4:00, at least in the state's estimation, because remember, the bodies aren't discovered until Tuesday. So they don't know what day that the crimes actually took place. Now we've got a 72-degree day, Mother's Day in May, and not one neighbor hears anything. In the states, they don't hear four or five gunshots being fired from outside of the house with a 9mm. No one hears any screaming. And, you just have to think about the reality of a 70 plus day, first beautiful day of the spring, late spring, and it's Mother's Day, and it's right around dinner time. I mean, what are people doing? Like they're grilling, man. They're out there grilling. They're in their backyards. So, when we start doing our own investigation, we go and canvass and talk to witnesses who would be willing to talk to us, which is another whole issue. It's like that part of it is something that people don't really understand, in terms of like us having access to a witness to be able to question them and see, because look, a cop asks some questions. I don't know if a cop was feeding them information. I don't know, or if I'll read a report, I have additional questions. So of course
they already have their story locked in.
Well, but beyond that, like the prosecution cannot say to somebody, I'm forbidding you to talk to the defense. Right. But what they can say is, well, it's your choice. You definitely don't have to talk to them.
Yes, it's completely up to you.
Right. And if you've got people that have already reached a conclusion on their own that they think based on what they're hearing in the press and based on what they're hearing from the prosecutor, this person did it, they're going to be so inclined not to speak to us. So it's like there's so much that goes against trying cases like this that makes it so much harder because the state has all the money, they have all the resources. Dude, the investigation that went into Garcia after he's arrested is like unprecedented.
How did they
Like,
land on Garcia? How did they land on him?
so basically when they kind of landed on it, like I don't know how far you went, like how far are you into the season at this point? Like have you started listening to that season yet?
Yeah,
Like
I have started listening to it.
and it's long, dude. So
Yeah.
like trust me, I ain't sweating you if you're not that deep into it yet.
Oh, I'm not
yeah.
near done.
Right. So like basically they get to the point where
I mean, I've gotten through the murders themselves.
right. Okay.
Yeah.
So you're probably to the juncture where the Thomas Hunter and Shirley Sherman killings, that case goes cold.
Yep.
For 5 years. They just can't figure it out. They can't find a motive. And if they don't have a motive,
that's the 11-year-old kid, the housekeeper.
That's the 11-year-old boy who turns out to be the son of the director of the pathology department in Creighton.
Right.
All right. So like in law enforcement initially is thinking that Shirley was the target because who in the world, you know, if it's not somebody that's close to the child,
would target an 11-year-old.
Which right, like who just got home from school.
Did they look at the dad?
Yeah, they did.
Okay.
You know, they did look at the, you know, and when I got the, you know, and the guy's a pathologist, and pathologists just by trade are kind of strange birds.
Oh, yeah.
A little bit, you know what I mean?
Psychiatrists and pathologists.
Right. And, you know, and like in terms of death, that's what pathologists do. You know, they deal in death. So, and they're very clinical. You know what I'm saying? So when I first got the 911 tape of Bill Hunter calling it in when he discovers that his son has been brutally murdered, it gave, like, I had chills up and down my spine. I'm like, oh my God. I'm like, he's like, I just walked into my house and it appears that there's 2 people.
3 stab wounds.
Right. But like, he doesn't react.
It sounds very clinical. Yeah.
It was 100% clinical. And it's like, it's not the response you'd expect from, like, if I walked into a house, God forbid, and like any of my 4 kids had been murdered, I'd be out of my mind. You know, like there would be no part of me that was calm. You know, so it's like this was the diametric opposite of that, and OPD felt the same way because they looked at Bill for a long time. Like they didn't, like he was alibied out though. Like, you know what I mean? Like he was at work. They knew he was there unless the timeline. You know, I mean, the
less
fact
they're
is
wrong on the timeline.
Well, but they didn't know the timeline other than the fact that Bill Hunter's the one who called it in. Right. You know what I'm saying? So they don't know, but they have this dude walking around the neighborhood like shortly after Thomas got home from school. Like that we have like 4 or 5 eyewitnesses that see someone that doesn't belong in this affluent neighborhood called Dundee in Omaha. Like it's all doctors, lawyers, you know, professionals that make pretty good money, real nice houses. So, you know, people in those types of neighborhoods keep their eyes out, you know, they're, you know, so they had some eyewitnesses that all kind of described for the most part. I mean, to the extent where they were able to do that, you know, they made they went to a sketch artist and they did they had a sketch that was done that was posted out and like released to the public. And it was a composite, you know, and all of them were kind of like, it kind of looks like what the guys, like none of them were like, you nailed it. The composite artist just crushed that, you know, because they all had different perceptions of what they saw, like we were talking about earlier. So, but they all said that the guy, you know, like had an ill-fitting suit and was carrying this looked like an over-the-shoulder like satchel. And, you know, a couple people saw this, what they believed was like a small Honda CRV or like type small crossover SUV type deal parked a street away. So like they had that, they just couldn't, you know, and so they looked at Bill Hunter. They just dismissed it. I mean, they polyed him. They kind of kept him on the radar. They interviewed him a bunch of times because they couldn't crack it. And, you know, and originally they really thought it was more Shirley because Shirley had a daughter who was in a very tumultuous relationship with a guy who had, like, months prior had broken her daughter's jaw, who was a meth addict. And so they were really kind of thinking, and Shirley had helped her daughter get an order of protection against this guy. Her tires had been slashed 2 weeks before. She was carrying a knife for her own personal protection. We discovered that she was keeping a log because she believed that he was dealing meth out of the little, like, she had a small house on her property, and behind the house that she lived at, that her daughter and this guy were living in. And she kept a logbook of the comings and goings of the people, because she was trying to, number one, she had grandkids with, that were her daughters, and she didn't want this guy around her grandchildren at all. So like there's
a real viable suspect,
very viable suspect. So, they were kind of, but the guy kind of had an alibi, not really, because he worked at a job where no one could definitively say whether or not he was there specifically at the times that they think that it took place. And again, remember, we don't know what day it took place. So ultimately, when the second set of homicides take place, somewhat similar. I mean, there were different MOs, because the first ones were all knives from the house. There was no gun used, and the knives were both left in the victim's necks, which our criminologist said is an absolute sign. Like, it's like that is a signature, like, no bones about it. Like, it's very rare. He's like, I've done cartel killings. I've looked at thousands of cases. I've never seen this where they left the knives impaled in the sides of their necks. So when you get
and had multiple knives, right?
Right. And they were all from the house, meaning that the killer came without a weapon to commit these crimes, which is extremely strange.
For a plan. So, yeah.
Right. Well, I mean, theoretically, it's planned, right? So, I mean, typically, if you're coming to kill somebody, you're going to have a weapon with you, as opposed to relying on the fact that you're going to be able to secure a knife within that house, not knowing how many people are going to be in that house. And then and for us, like, adding in the factor that, look, if Garcia's the guy and his theory of revenge is that he's going to kill the child of the man that he feels destroyed his career, that's a very specific MO. And to kill a child is a very different mentality than killing an adult. It just is, so like we're looking at that and like, man, it doesn't fit. It really doesn't fit, because there's no way Garcia would, like, he would know. He worked in that department. He would know that Bill Hunter wasn't going to be home at 3 or 4 in the afternoon when they think that homicide took place, So it's like, so you then know if they're going to make Thomas Hunter the target, that, and theoretically thinking that Shirley was Bill's wife, that is a very specific MO. And then you go to 2013 when the Brumbecks are murdered. Again, instead of, him killing a child, it's then because there's the connection. You have Bill Hunter, who is the director, and then you have Roger Brumbeck, who was the former chair of the pathology department at Craven. That's the link. So at that point in time, they've decided that is the common link between these two crimes. We feel it's the same person that did them. So they then start digging into former residents. And they go through a laundry list of anybody that may have had beef with Creighton. And ultimately, they land on a few different guys. Like, there's the Russian Michael Belenky, who was the primary guy for the longest time. And then, like, Garcia started popping up, and Garcia had a real rough time there. They start digging into his past. They see that this thing has affected his career. It's followed him, because that concept of waiting 7 years before doing something is kind of like,
quite a cooling off period.
Yeah, that's quite a cooling off period. But they, then they discover that 2 months before the murders, that he'd been fired from LSU based on the fact that he had lied on his application and did not put in there that he had been a resident at Creighton, and that LSU, in doing their due diligence, found out that that was it, and they terminated him. So, but he doesn't know, like, they could never prove that he saw a letter that was the cause. Because I had that woman on the stand, I mean, it's like, could he have assumed it? Maybe, but there was this concept that, like, once he got fired, and if you didn't finish that first year of your residency, that is a death knell, that you can't get another residency. But he did get another residency the following year based on a recommendation from Bill Hunter, which we had that letter because he went and got a residency with the pathology department at UIC here in Chicago. So, it fit in a lot of ways, but there were a lot of things that didn't really kind of add up. But like we felt going in that their narrative was strong enough that we had to really dig into the evidence and basically how it really always is. Yes, there's a presumption of innocence, and yes, it's 100% the burden on the state to prove the case beyond a reasonable doubt. We don't have to prove anything. That's just not how it really works in application. Like in a case like this, we have to prove that our guy didn't do it. There's no question about it. So
wasn't there another murder too that was somewhat similar to one of the, like a third murder?
Yes. Yeah. And it predated Thomas Hunter and Shirley Sherman's by about 4 months. And it was the MO was the same. It was a woman named Joy Blanchard who had been murdered, and the knife had been left in her neck. And that case was also cold. And that place was like, but they couldn't make a link between either Sherman and Hunter and Joy Blanchard. They couldn't make that link, which for them, even because and what shocked us is that they had redacted all of the investigation because they initially, Omaha PD believed that they were linked because of the MO, because of the knife being left in the neck. And when we get the discovery, there's not one mention of Joy Blanchard anywhere, which tells us that they went back and either extracted all of the reports that had any investigation into these being linked because they didn't want us to start looking into it. So Allison actually was Googling and found out about that murder, and we had to file a motion.
Why wouldn't that be a Brady violation?
I mean, we argued it, but dude, like everything about this case was just bizarre. Like our initial judge, who was the judge for the first 2.5 years, who had no experience with a case like this at all. Like had never, like he was over his skis. Like he denied all of our motions, which
was like the first judge in the Delphi murders.
Exactly. And so this guy, like 2.5 years in, who had denied our motions to sever the trials, who had denied our motion for change of venue, who had denied our motions to suppress based on, and to quash the arrest based on various things that were all constitutionally sound arguments. And frankly, the motion for change of venue should never have not been granted. That 100% should not have been tried in that county. There's no way it should have been. You could never get a fair trial there. So this guy, like all of a sudden claims that he gets sick and that he can't continue on the trial, which is a huge disadvantage. Like people don't understand. It's like, this is the guy, because the judge is the gatekeeper of the evidence. Like everything that happens,
right.
But like the war is waged in
the institutional memory. Yeah,
that's it. So then they bring in a guy and it's already set for trial. And of course, Doherty, who's the original judge, never misses a day of work ever. He's never not on the bench. So whatever this sickness was, seems to me to have been completely fictitious. And then they put on this new judge, Judge Randall, and he's definitely a more assertive judge. He's definitely handled bigger cases. Like they obviously internally felt that he was the right judge because they knew the fight that we were putting up.
Thinking they could lose an appeal because of who the first judge was.
Yeah, 100%. And then like this story could go on forever, dude. It's like it really is. I mean, this trial was unbelievable. Like it was like just the battles that went on. It's like, to me, it's the most fascinating trial. Is fascinating as people thought Murdough was. This thing is even more fascinating procedurally. It's unbelievable.
Talk about the DNA. The DNA seems
so there was no DNA.
Yeah,
that's the thing.
Yeah.
So there was. So what they did, like in terms of building out their narrative, it was a really bad fact for us, though. But it was something that we attacked. But so there was a doctor, and when you kind of get into us digging into Garcia and his time at Creighton, you'll learn the name. But her name was Dr. Butra. Like this was Garcia's arch nemesis. Like she was an Indian doctor. very seasoned, very bright, very stern in terms of her teaching approach. Like, she did not tolerate people that weren't doing the work. She did not tolerate people that she thought were lazy. And she thought that Garcia was all of those things. And she was a tough love type of teacher. So she would undress her students, because residents are still training, I mean, there's still an academic side of that. It's not, there's practical experience, but there's also, education that's still continuing to go on when you're a resident. And she could not stand Garcia, and Garcia could not stand her. And she would like undress him in front of other residents saying, how do you not know this? What do you do? Like, what are you doing? Are you not reading any, like, how, like, you should know this by, like that kind of relationship. And so Garcia, had to like gone off on her a couple of times verbally. And, Hunter had gone to him and said, look, man, like, she is your superior. I need you to understand that unequivocally. Like, you cannot do that. Like, you are on super secret probation right now. You pull any more stunts like that, you're done here. I'm just telling you that. So that relationship was awful. And then ultimately there's this prank that is pulled by Garcia with another resident where they call another resident's wife while he's taking his step 3 exam and say, hey, we're calling from Creighton. We just wanted to let you know that your husband's vacation time was not approved and he needs to leave the exam and come back to the hospital right now. So they quickly figure out that it was Garcia and this other guy, Brian Wynn, and they terminate him immediately. They're like, that is beyond unprofessional. You're gone. So he gets terminated. And, and he, like, they gave him the opportunity. Like, they said, look, you can kind of like own this and resign. Okay. And we'll help you. We'll make it appear as if you finished a full year, or if you're going to fight us on it, because firing, like, these are contractual employees, like liability is always an issue for them in the minds of the lawyers for Creighton,
Right.
Like, it's a very real thing. Every word that is written is parsed by the lawyers, so like in terms of how it goes down, Garcia's like, no, I'm not going to resign. I'm like, you guys are like, I feel like that you're like, I'm being treated in a discriminatory manner because I'm Hispanic. And like, there's no one's going to tell me otherwise. I think Butra treated me that way because I'm Hispanic. I think you're treating me that, so he, like, that was a real thing for him in his mind. Like, he thought, so he refused and he ended up appealing it. So they upheld both of his appeals. So he's terminated. So then on his record, it appears that he didn't finish, and they then have to report that to the national database that he was terminated, and they give a very generic, for unprofessional behavior, so like that. So that's out there. It's floating out there. And like Garcia kind of made that bet himself, So yeah, as that thing kind of progresses, it just gets to the point where, all those years pass and Omaha kind of like sees these things that kind of keep following him. But the problem from our perspective is what they just couldn't show that Garcia was aware. I'm like, do you have letters that show that he was carbon copied so that in his mind, he knows that it's Bill Hunter?
Told them. Yeah.
Right. Exactly. And those facts just didn't exist. So I don't know, man. Yeah, it's a mind blowing case, man.
Yeah.
But like, it's like, and when we start getting into the evidence in terms of, like, if Garcia was the guy, it didn't happen in the time that they said it. It couldn't have happened at 4:00 in the afternoon. And I'm not basing that just on the fact that nobody heard it. I'm basing it on the fact that Roger Brumbeck was in rigor mortis when they found him on Tuesday. And physiologically speaking, scientifically speaking, that's impossible. And I hired the most preeminent forensic pathologist in the world to testify to that extent, who was Werner Spitz, who had done he had done every big case. He was like did the autopsy on Kennedy for the Warren Commission. I mean, the guy's, he was like a relic. He was like 90, but but the guy was like a superstar witness for us. And then 2 weeks before trial, CBS airs this John Benet Ramsey special, the 20-year anniversary of John Benet Ramsey, where they put together a panel of experts. And of course, Spitz is the forensic guy. And he, on this show, unequivocally says that he believes that John Benet's brother killed John Benet, and says how he did it. the brother then turns around in a matter of hours and sues him for $200 million. And I'm trying to deal with his dude. It's like, and I'm trying to deal with Spitz's like New York attorney. And he's like, I can't have him testify because this judge is going to allow them to voir dire your expert and get into this. I'm like, that was a TV show. I'm like, they have to stick to what his professional opinion was. That was for entertainment value. The judge is like, I don't care. I'm going to let them ask anything they want. And so his attorney said, I can't let him testify. So we lose our star witness who was going to testify that science says that they could not have died on Sunday because he would never be in rigor mortis anymore.
This all makes me think of something. Do you ask your clients? Do you ask them
if they did it?
Yeah.
No, well, I mean, we didn't in terms of Garcia because he denied it from the minute we met him. He's like, I did not do these. Like, I didn't do any of them, you know? And it's like, so, but I mean, as a general rule, we don't ask because it doesn't impact our job in terms of whether they did it or they didn't do it. Now, what we do is when the discovery comes in, and I like, because everybody comes in and denies. Like it's not like TVs and movies. You know, defendants aren't coming in and the lawyer's not saying, you have to tell me the truth. I'm your lawyer. You know, it's like that doesn't happen. It's like people come in and say, man, I didn't do this. And then when you get the discovery in, you say, all right, I need you to come in the office. Let's go through this discovery. And, you know, I'm saying, hey, man, they got a lot of facts, bad facts. It's not looking good. So, like, I'm not telling you to confess anything to me, but I'm just telling you that the evidence makes it look an awful lot like you did this. Right. So, you know, like we have that conversation, but like on the front end, I don't like, you know, it's just like, that's fiction. Like, oh, did you do it? I need to know. You have to tell me. I can't do my job if you didn't tell, because you can do your job.
So you might ask them, hey, what do you think they have? You know,
well, that's the exact question we ask.
Yeah.
What the exact question we ask is like, and we tell them, we see, do not tell us what you did or didn't do. Tell us what they're going to say that you did or didn't do. You know, what are they saying that you did? And that we frame it that way very carefully, because if we come up with an alternate defense in terms of us researching the case and going through the discovery, and our client has told us something early on that I can no longer put him on the stand because I'm not going to have my client suborn perjury because it doesn't fit with the theory that we've created. You know what I mean? So that's why, you know, you never ask them that question, because, you know, I want to be able to vet the evidence.
Right.
You know, in terms, and frankly, they're going to lie if they did it. They just like, I've never had a client in 20 years that came in and just said, yeah, I did all this.
And I did it, man.
Yeah, I did it, man. You got to get me off this shit, dude. Like, you know, it doesn't happen like that. So, you know, like typically it happens, like we go through the evidence and I'm like, all right, we need to talk about a plea deal. You know, it's like this isn't magic, you know, like no silver tongue, like lawyer is going to be able to get you off these bad facts, man. You're done. They got you dead to rights. So let's look at this pragmatically and let's figure out, you know, let's see if we can get you the best deal we can, you know? So it's, yeah.
Yeah. I wanted to ask you one thing about sort of like thinking from a defense attorney's perspective. You know, you made the point, right, that we sort of convict people in the press before cases. And it sounds like that certainly happened in the Garcia case. I'm thinking of some of the current cases, like the two girls, Abby
Delphi.
and Libby, in Delphi, kind of convicted in the press in advance. Abby is Abigail Williams, and Libby is Liberty Germain. They were kidnapped on the historic railroad bridge in 2017 in Delphi, Indiana. And what's fascinating about that case is that it took 5 years to get an arrest, even though Libby recorded a video of the killer approaching them on the bridge and audio of him saying down the hill. Although probably people have more
less so than the Idaho 4 guy. Like, like I did an episode on the docket, which is our one-off, you know, where I just talk about current stuff, comparing those two PCAs. Because I was having these Twitter wars with people that I suspect were not attorneys that don't deal with probable cause affidavits for a living, that were like, they're withholding the strongest evidence in the Richard Allen thing. I'm like, no, they're
absurd.
not. Right. That is not what
Absolutely absurd.
Right. I'm like, this is the state's best opportunity to put their best foot forward in terms of getting this out to the public at large. They have included every single piece of good evidence that they have in their possession at that time. Like,
because
without question.
they're trying at that moment, because they're probably going to have a hearing,
Exactly, where I am trying to dismiss it based on a lack of probable cause.
But yeah, and they're also trying to sell it to the public too, 100%. Right?
Yeah, that's a huge advantage. It's like you and I just talked about that 20 minutes ago. The state has that massive advantage of being in the position to get their theory of the case out to the public long before the defense has any ability to say anything or challenge any of the evidence. So they always put their best foot forward. Now, are they going to keep out bad facts? Of course. They're not trying to, you know what I mean? So could they have information that they've not put in there? Yes, but it's going to be bad information. And like that Richard Allen thing, paper thin. Like that.
Yeah, I read that and I thought, okay,
like, oh
why?
I was like, right. I was like, what? I was like, this is not a good one. So like when the Idaho 4 one dropped, I was like, wow, okay, so here you go. Like, this is what a strong lean towards guilty, like it's trending guilty PCA looks like. This.
What's the difference for you between those two? Yeah,
just the fact that you've got time and data from the phone. You've got video of him or his vehicle being in the area around the time that we pretty much know that the homicides took place. You've obviously got the sheath with the DNA on it. You've got, they had him in the area. I mean, we definitely know for a fact that this guy was in the area at the time. And now, whereas with Allen, we do as well, but by his own statement. And I always take exception to the fact when people say, Allen admitted it. No, the word admitted has a very different connotation than volunteering the information.
Well, and even if you're going to use admitted, it's one of hundreds of people who admitted they were there that day.
Right.
The search parties.
Right, but do you understand what I'm saying by admitted? Yeah. Admitted means it implies that you've done something wrong and that you're admitting that you did it. Whereas, like, basically what went down in Delphi is, the girls went missing. They came out with a public statement asking the public, look, if you were at the bridge that day, please come and let us know. We need to try to figure out who was out there. This guy did that. Like, it didn't matter whether, like, and people were like, well, and like what I've heard is that he did it the day of that the girls went missing, that he went to the resource officer. Yeah. And that, he made that statement the day of, and so people, their retort to that is, okay, well, yeah, but he didn't know about the video. I'm like, it doesn't matter. If he's the guy, he's not going and telling them anything, period. Like, just use your common sense.
Cover it up,
whether there's a video or not, right? He's not going and admitting. He's not putting himself at the scene of the crime if he's the guy who committed the crimes. I'm sorry. That does not happen. Because it's different than people, because yes, killers will go back to the scenes or they'll show up at a funeral, but it's different than going to law enforcement and saying, hey, yeah, I was there the day that it happened.
Yeah, they might lurk, like they say.
They creep back, admire their handiwork. That's a different thing than what happened here. So, in that whole, that ballistics, and you can't see it, but I'm using finger quotes around that, with the ejected unspent casing, like, that is not a real thing. That is not real evidence. There is never if anyone that listens to this podcast can provide any kind of precedent in terms of an appellate case that has been tried where somebody has been convicted, not from ballistics and tool markings coming through a barrel, but being ejected.
Right, because they just from the shell case.
They found an unspent casing. It wasn't fired. It just popped out. And we were talking about the most common, like 9mm, the most common ammunition purchased on the market. Everyone, like, 9mm are one of the most if not the most popular and most purchased caliber of weapon. It's just a very common weapon in a state that is absolutely, Jason, gun crazy.
Yeah,
like Indiana. Right. there is no cooling off period. You get like there, you don't have to have a FOID card. Like in Illinois, you have to have a fire owner's identification card. You don't have to do any of that in Indiana. You want to go buy a gun, you go buy a gun. They have guns. They are packing there like that. Like everyone has guns. So, and for them to like, and they worded that very carefully in that PCA. Like they did a CYA on that. If you read that sentence very carefully, that, the person who made this determination that, look, this is completely subjective as to that person. We're not necessarily saying it's us that's saying that it was his weapon.
Right.
Like they worded it very carefully in that, which is very telling. So, and I want justice for Abby and Libby. We all do. Like, absolutely. I think that if they're going to get this guy, it is not on any of that evidence, that it's going to have to be the stuff that they get post arrest, which is frankly when most of the investigation takes place. Like you'll see in Garcia, all they had was him present in the state. Like that, when they got the ding that his debit card was used at a wing stop in Omaha on the day that they believed that the murders took place, that was it. They ran in and got the arrest warrant with no physical evidence connecting him to either of the scenes. They're like, he was there. He's the guy, so like it's a very similar situation with Richard Allen, except they have like just like maybe a hair more if you were to buy the spent cartridge thing, because that's all they have. I mean, well, dude, I saw this guy in person and he is like 5'3".
Oh, you saw him in person?
Yeah, I feel like I've been
to go. Yeah.
Yeah, I've been going to the hearings because Delphi is like 2.5 hours. So I'm going to go cover that whole damn thing. I'm going to be like in June for this thing that's coming up, which is his bond hearing where they're asking him to set a bond. The state, by way of it being a death penalty case, it shifts the burden to them where they're going to actually have to put on evidence. This isn't going to be like your normal bond hearing where you're just going in, the state's given the factual basis, and then, we're basically begging the judge saying, look, this is a good citizen, they have a job, they have kids, blah, 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 set a reasonable bond amount. This is a different thing because of the nature of the case. They're attacking that PCA. They're like, because in that case, if you'll remember, it was a rare circumstance where the defense actually fired out a letter.
Right after.
Right. Yeah. They're like, yeah, okay, well, everything that PCA says about our guy is BS because like, and this is why, so they had the reply and that came out, so what they'll find if he's the guy and they're going to be able to prove it, it's going to have to come from data, like from his computers, if they found anything in the house, and there was 5 years that passed, man. I mean, if the guy is the guy an idiot, like the guy commits the crime, but he keeps the same jacket, he keeps the same weapon, he's like, he's figure, well, the girls didn't get shot, so I'll keep the weapon because like he's not aware that a bullet discharged out of it. Like, I mean, it's like there's just, it's like, man, I want that case to get solved, but it's got to be the right person. So we'll see. It's like,
what do you think life is like for those defense attorneys right now?
I think in Allen, they're chomping at the bit, depending on what they find. You know what I mean? It's like, like
let's go have the trial tomorrow.
Yeah, but that's the thing. That's the only thing that gives me pause because of this massive. Like I have never, and I was talking about this with Brett on a prosecutor's episode that we did, legal briefs that we did. Like neither of us had ever heard of a bond hearing being this far out. It's unheard of.
Right.
It really is. Like we're talking months, 6, 7, 8 months. It's crazy for a bond hearing. So, and the fact that they didn't do a speedy demand is telling to me. But speedy demands are scary. Like in retrospect, I wish I would have done a speedy demand in Garcia because of so much of the crap that they put in a trial is stuff that they got after the fact.
Well, because you're in confirmation bias mode too.
Totally.
Prosecutors and police. Totally. You're looking for any connection that you can make.
Right. At that point, you're like firmly locked on that guy. You know what I mean? It's like I make the argument in Garcia that, they had tunnel vision immediately, like as soon as they locked into the concept of it being a Creighton connection, they forgot about everything else and they didn't look at anything else, which, after 5 years of the Hunter thing, they're like, man, we're not doing that again. Cause we didn't get anything off that. Like we just couldn't figure it out, so I get why they did it, but at the same point, because man, as soon as I start thinking about Garcia, I just like start having PTSD. It's crazy.
Well, and that's actually a thing I think that a lot of defense attorneys experience, and those,
Oh man,
like I hear them often saying, like, "Well, what if I had done this? What if I had done that? What if I had taken this?"
always double guess.
Carry a big weight. Yeah,
Always, dude. Like you can't help but do it. Like if you have a client that's going to be executed on your watch, like try to imagine that.
yeah.
I mean, like it's constant, like and then like they filed an appeal on this, and they're like, and we knew they were going to shit all over us. I'm like, dude, read the transcript of the trial. Like I'll let that speak for itself. And the problem with that is that because they were focusing on the fact that Allison got removed from the case and all, like the things that they shouldn't have been focusing on instead of the actual appellate issues. Like
There were separate appellate attorneys, right?
yeah, well, yeah, because like you never want to like handle an appeal if you were the trial lawyer, because and for me, I take no. I harbor no ill will towards them for saying ineffective assistive counsel, because they do.
Well, you can't. I mean, you can't use the most likely to be effective defense on appeal, which is ineffective.
Exactly. So like in like this thing that they put together, like they violated his Sixth Amendment right by taking Allison off that case, which was completely unwarranted. And because we fired right back at them. I tried to have Don removed for the exact same thing. He was doing the exact same thing that Allison did, except for years. His fireside chats, the governor of the state reinstating the death penalty, because the death penalty was repealed there. And the governor, who's Ricketts, puts together a PAC with his own money in order to get it back on. And he's like, we need the death penalty for guys like Anthony Garcia.
Oh, wow.
Prior to my guy being convicted, like in the press saying that.
I didn't even know that.
Oh man, dude, it was a never ending railroad. But it kind of goes to that thing. Like I sit here today as we speak, not knowing whether or not he did it. Like, honestly, like I say that in the beginning, like I sit here, like that's why I tell all my listeners on my pod, I'm like, I'm giving you guys all the evidence, and I can't wait to hear where you land on this. Because I want to actually have a jury of Garcia's peers who are my listeners who hear all the evidence. And I want to hear what you guys say, where you've both heard all the evidence, where you're not watching my clients sleep through it. And so you don't have a predisposition. So I'm fascinated to hear it,
In most cases, do you not know?
I mean, you never know, dude. That's what I'm trying to, that's what I'm saying. It's like at the end of the day, what I try to explain to people is you have a prosecutor and a defense attorney that both just have a story, a theory that they have based on what their perception of the evidence is. And that's it. None of us really know.
Right.
None of us do. Like two people know. Again, the victim, who in a homicide obviously is not with us anymore, sadly. And then you've got the perpetrator, the real perpetrator. Those are the only two people who definitively know what happened, aside from a case like where you're in a restaurant, somebody comes in and blows somebody's head off, and they're like, that was definitely the guy. Or, yeah. I mean, in a case where they have direct, like smoking gun evidence, that's different. But in a circumstantial case, we never know. It's like Brett and Alice with like the Scott Peterson thing. Like they are all day. That guy is guilty as hell. I don't care what anybody says, but they don't know.
We don't ultimately know.
Right. I mean, they can put together a compelling, and it's like, and I listen to it and I'm like, yeah, it's compelling, but we still don't know. I can put like, we just don't know, and it's like, yes, like, I mean, it's torturous, really. It's like that on every case though, that where there isn't that smoking gun evidence, where there's always just that one little kernel of doubt.
Piece. Yeah, it sounds like it's really interesting listening to you talk about Garcia. It's almost like the podcast is giving you your first chance to truly have an impartial jury.
Exactly. And that's exactly what I say in the first episode. I explained it. I said, I am going to give you everything. This isn't slanted defense attorney guy podcast. I'm giving it all to you. I'm going to put, like I said, all of the bad evidence in terms of Garcia. You're going to hear it. But then you're going to finally hear the defense and then make your judgment, because like I'm telling you, the scientific evidence is pretty compelling. It's pretty hard to deny the scientific evidence. It's like,
If you were to sort of like step back and think about what you would want, like us, the general public, to either know about sort of trials or that role of our role of being jurors, is there any kind of message you can think of that
yes,
you would?
it's
Yeah, go.
a very simple message, and I'm like puking this thing out constantly on Twitter. I'm like, look, this is the reality. It is absolutely human nature to form an opinion when you start hearing, albeit the facts that are the state's theory of the case initially, either through the media or online or on socials, wherever you learn about a case. Our human nature is to initially form an opinion as to guilt or innocence. What I am begging everyone out there to do is fine. I'm not judging you because we all do that, but don't make it your final opinion until the evidence is vetted. It is the entire purpose of a trial is for us to
Mm,
hear the evidence because you initially are seeing everything through the filter of the state or the police, who they believe wholeheartedly that they've got the right guy, or at
mm,
least they should. We hope that they do. So but it again, it's their theory. They were not there. They were
right.
not present at the time that the crime was committed. They are doing exactly what the defense does, except they're doing it in terms of being a prosecutor, and they're putting a jigsaw puzzle together piece by piece by piece. There's going to be pieces missing, and there's going to be pieces that might not fit just right. And that is the purpose of a trial. So yeah, go ahead, have your initial opinion, but please just keep it that, and
Right.
don't land on that being your final analysis of the case, because you're doing a disservice to everyone. When you do that, you have to wait, because look, like, this misnomer that everything goes to trial is completely inaccurate. 95% of cases are pled out. The things that we see go to trial tells you one thing, maybe two. Like, there is occasionally the defendant who's just adamant about going to trial, even though
Hmm.
they've got him dead to rights. But for a vast majority of cases, when you are seeing a case that has gone to trial, there is a dispute as to the evidence and the facts. If it's at trial, you should take from that fact that it is going to trial, that there is a legitimate dispute as to how the facts have been perceived or interpreted. And
Yeah.
and we owe it to everyone, to the victims' families first and foremost, to the victims themselves, to go through the process, to listen to the evidence, to see what is what, because until it's vetted at trial, you just don't know. You need to have that opposing party say, all right, I hear what you're saying about this evidence, but what about this? And then at that point, you have an informed ability to make a decision whether or not you feel that that piece of evidence is sufficient in proving that person's guilt. You can't do it otherwise. Otherwise, you're guessing blind in the dark. You know what I mean? So that's it.
Yeah.
So that the message is that have your initial opinion, but just consciously tell yourself that's not my final opinion. That's what my first opinion is, but it's not my final. That's it.
And it's how I feel about a lot of the cases. Like I think about the trial of Alex Murdough down in South Carolina, and I think to myself, like, if you put a gun to my head and you made me choose, I would probably
So
say I feel
hard.
like he's guilty, but could I
Dude.
have convicted him based
Same,
on what I
dude.
saw? Not so sure.
Same, dude. Same. Like, God, I was so on the fence on that. I'm like, it's like Garcia. It's like they have this narrative that's super compelling. And like clearly the guy is an absolute turd. I mean,
Right.
anybody who steals his clients who have either suffered like debilitating injuries, stealing their money. I mean, he's a despicable human being. Take that out of the mix and just look at the facts. And like Creighton Waters knew that. That's why there was such a battle about the 404 stuff, about whether or not they were going to allow all the financial stuff to come in, because it's like you can't use 404 stuff to show propensity that he's, this is what he does.
Creighton Waters is the prosecutor in the Alex Murdough case in South Carolina.
And you can't use it to show what his character is per se, so they used that, and everyone hated the motive, like that motive argument. Everyone was like, that's the worst motive of all time, so it's not a good motive. But that wasn't what he was really using it for.
Right.
He knew that getting it all out was going to create that perception that this guy's just a
bad guy.
Right, just a bad guy. And if they're sitting on the fence, which all of us had to be, that you're going to lean guilty and you're going to find him guilty. And and it created a situation where Murdough had to testify.
Right, right.
I mean, everyone's like,
do I believe this guy as he has a stack of all these things?
Right, because the big lie, that's what I call it, the big lie, the kennel lie. I'm like, man, this, they either Jim and Poots misadvised him. I'm telling Murdoch, and Murdoch's of course the smartest guy in the room. There's nothing worse than having an attorney as your client
who's convinced,
right? Who's like, dude, I am and frankly, the guy's superpower was being, incredibly manipulative, and it had an exceptional ability to lie to people right to their face. I mean, that was a superpower. It was proven. That was without exception. So he took that in that trial, believing that he'd be able to do the same to the jury. Right. So he went in, but in terms of how he handled that big lie about being down at the kennels, saying that he didn't trust SLED and that's why, nah, man, and I say it in one of my pods about it. I'm like, look, it was simple. The way that law enforcement looks at any case like this is they are going to look immediately, and he knows this. He was a solicitor or a prosecutor down there.
Right.
He knows definitively he is the last people to see them alive, his wife and his son. He is the husband and the father, and he is the person who discovers the bodies. He is the guy. He is the guy that they're looking at immediately. If he would have just admitted that and said, look, I was not willing, knowing all of that, I was not willing to put myself down at the kennels closer to the time that we think that they died because they already think that I'm the guy. And I didn't want them to get locked in on me to the extent that they're not going to look for anybody else.
Right.
That's how he should have explained it. It's more plausible. And if he didn't do it, it's true.
And then you know what I mean? I felt like I couldn't get out of it once I told the lie. Do you believe in that line that it's better for 10 guilty persons to go free than one innocent person?
Absolutely. 100%, dude. Are you kidding? When I see these guys coming out after 30, 40 years, exonerated, full blown actual innocence, it's man, that you have to try to put yourself in that in that person's shoes for just a minute, but really think about it. Yeah. I'm talking about if I'm ripped away from my 4 kids and my wife and everything that I've known of my life on some shit that I didn't do.
Yeah, and convicts count those hours by the second.
Oh man, dude. Yeah, no, I live by that. Yeah. I live by that because, it's because more likely than not, if somebody's guilty and they're a criminal, they're going to do something else and they'll just get right back up in there. I mean, that's a fact of the matter. I mean, that's kind of the nature of the beast. And it's a whole different conversation in terms of society and, the kind of where the people are cast in terms of where they're born and what they're born into and how society treats people. And, there's a lot of factors involved without even touching into, the mental health side of it and, the addiction side of it. I mean, there's a lot going on, man. These are every single person.
Well, we want them to be cookie cutter, right? We want them,
but it's it's not.
There's this human need for the simple narrative, and rarely
it's easier to stomach it that way. Yeah, it's easier to not have them be human,
or even easier to sort of think if I know a simple narrative, then I'll know how to make sure this never happens to me.
Right.
Right.
Exactly.
And so we often simplify things. So Bob, I wanted to give you a chance for any closing thoughts that you wanted to throw out there.
Awesome.
This has
Well,
been an
first,
awesome conversation. I
it has,
appreciate
dude.
it.
I've really enjoyed it. I love doing this stuff. I thank you for having me on the pod. It was an absolute pleasure. I'm excited about our burgeoning friendship. I'm sure we'll be talking a lot over the years, man. So, first of all, I wish you luck on your pod. I know you're just getting started on this bad boy, man. But
Thanks,
I
man.
like where you're going with it. I like obviously biased, but I think this is a pretty interesting conversation. So I hope that your listeners enjoy it. If you want to find my pod, again, it's called, and I know Jason gave you kind of a little love for my pod in the beginning, but Defense Diaries, it's available anywhere. Get your pods. We do have the serialized, and they are deep dives. So like if you're like a one-off, we've got you there too. We got the little docket episodes where we handle current cases and breaking cases, but we have a very, very serious deep dive. I think that there's probably maybe only two other pods that are as deep dive as we are, and that's the Murdough thing with Mandy, and then my buddy Josh Hallmark with True Crime Bullshit, where he dives into Israel Keys. Like, we're the deepest in the game for sure. But we'd love to have you listen, and just remember, the one thing that I really decided kind of late in terms of creating the podcast was I initially wasn't going to inject the fact that I was a criminal defense attorney into it. I told my wife, I'm like, nah, it's like, I'm trying to get away from that. And then I realized very, very shortly into the journey that was the wrong approach. And, I just want people to kind of understand that the justice system that we live under, we need both sides, and we need competent attorneys on both sides, because that's the only way that justice can be done for the victims, for their families, is having competent counsel on both sides, because it's the only way that justice works.
Well, Bob, and I think we all got a lot out of that decision to bring that perspective to bear.
I appreciate that, man.
This is the second of what's been a fun 2-part series with defense attorney Bob Motta. If you haven't heard the first episode, I recommend you go back and listen. And if you haven't checked out Bob's podcast, The Defense Diaries, I recommend you check it out. Until next week, I'm Jason Blair, and this is the Silver Linings Handbook.